Hello, good evening and welcome to your daily dose of Satoshi's news. Today's date is Tuesday the 16th of August 2022. Without further ado, let's just jump straight into it. Buy BSV.live, the best place to buy Bitcoin SV online, the original protocol and genuine Bitcoin. Here we go. Check this out. An article by the Law Society Gazette says Court of Appeal to consider crypto duty of care. Let's have a look at this then. The question of whether developers of cryptocurrencies and other blockchain-based assets owe a duty of care to investors in their products is to be examined in the Court of Appeal. Ruling last week in Tulip Trading versus Van der Laan and Oars, Lady Justice Andrews granted permission for a Seychelles company owned by Dr. Craig Wright, who claims to have invented the Bitcoin digital currency, to appeal a judgment by Mrs. Justice Falk of 25th of March, denying jurisdiction over a claim for breach of fiduciary and tortious duties. The company, Tulip Trading Limited, is seeking to bring proceedings in the High Court that would require 16 Bitcoin developers based around the world to write software patches to enable the recovery of assets worth more than $1 billion stolen in a 2020 hack on Wright's computers. The March judgment dismissed the claim that the developers owe any continuing fiduciary duty to users of their open source software. However, in granting the appeal, Lady Justice Andrews said, the issue as to whether the developers owe duties of care and or fiduciary duties to the owners of digital assets, and if so, what is the nature and scope of those duties, is one of considerable importance and is rightly characterised as a matter of some complexity and difficulty. Given that in addition to its complexity and difficulty, the underlying facts will play a significant role in determining that issue, it is arguable with a real prospect of success that it is not susceptible to summary determination in the context of a challenge to the jurisdiction, and therefore that the judge fell into error in deciding that there was not even a serious issue to be tried in the approach she adopted. Wright's solicitor, Oliver Kane, partner at Specialist London Forum Ontario, said, "We are grateful that Lady Justice Andrews recognised the wider importance of establishing in law the responsibilities of developers of digital assets to end users. The complex and fact-heavy considerations that characterise developers' duties to those who have lost access to their Bitcoin deserve to be explored and determined at full trial and not to be dismissed through jurisdiction challenge." A Law Commission consultation on the legal status of digital assets opened last month, but does not specifically address the duty of care issue. Wow, this is going to be big. So again, if a digital commodity network is maintained, and therefore anybody who maintains it would owe a fiduciary duty of care to the users who use it. It's just simply common sense. Even more so if the digital asset network is a securitized network, because a digital commodity network can only be commoditized one way. And if it is a commodity network, then it is a common effort, a common enterprise. However, if it is a security network, like all the shitcoins on the market, they all have a central point of authority or control. The developers absolutely owe a duty of care, but then they need to be registered as securities. This is going to be very, very interesting. So watch this space. I hope you enjoyed the show. As ever, be aware, take care, stay safe out there, and we'll see you in the next one.